Yes, it is.
You know, I could start 30 seconds early. I had 1 hour of material. That's it. Hi, how are you? I always love that laugh. Is he just kind of said that? Yes, I am. The clock turned 11. Now we can start. Hello, welcome to Boozy's Basic Law. I'm the Boozy Badger. Before we begin, let me just say a few things. First, I'm a lawyer. I'm a licensed attorney in the Commonwealth of Pennsylvania. I'm admitted to practice between the Eastern, Western, and Middle District of Pennsylvania federal courts and the Third Circuit Court of Appeals for the United States Circuits. That said, I am not your lawyer. We're going to discuss a basic legal concept today. I'm going to try to do it in more of a Socratic method, where I'll kind of pose a question, listen to the response. Things I'm not going to be doing is giving you legal advice. While today's topic is going to be one that is generally applicable throughout the nation, the way different circuits and different bankruptcy courts have interpreted it differ. If you have an issue, please go see a lawyer that is licensed in your jurisdiction. All right? Two, no attorney-client privilege attaches, because this isn't legal advice and I'm not your lawyer. Plus, there's a lot of other people in the room. Please don't say anything about a specific legal situation for you, okay? Finally, and I do have to say this, since I am an attorney for the Commonwealth of Pennsylvania, anything we discuss today is my personal opinion and does not represent the opinion of the government of Pennsylvania, okay?
Okay.
All right. So, what's bankruptcy?
It's weird.
Yes.
It's like where you're in a lot of debt and you need to give up a lot of stuff to have that debt forgiven.
You have to give up a lot of stuff. Why would you think that you have to give up a lot of stuff to file bankruptcy? Well, first, do you?
No.
No. Let me ask, how many people in this room right now would know how many chapters, what a bankruptcy chapter is?
There's like 7, I know 7 and 11.
Do you know 7 and 11?
Yeah.
So do I. It's a wonderful gas station down the street. Do you know what a chapter 7 is?
That's that, where, I know there's a, well, I was just explained it a long time ago to by a friend of mine, because I was thinking about doing it myself, but I didn't have any, like, property that was in my name, or a place that I even stayed that was in my name at the time, and it's like, well, it wouldn't be a chapter 7, it would be a chapter 11, and I still don't know what the difference is.
Why would it be a chapter 11?
I don't.
Are you a multinational corporation and none of us are aware of it?
No.
Alright. There are 5 chapters of bankruptcy. The bankruptcy chapter is just legal speak for type of bankruptcy. Why do we call them a bankruptcy chapter? Bankruptcy exists at Title 11 of the United States Code. That is, the statutes of the United States of America. Within Title 11, there are chapters. Chapter 1, Chapter 2, Chapter 3. 11 U.S.C. 101 is part, 11 U.S.C. 202, 11 U.S.C. 362, and so on and so forth. There are different types of bankruptcy within there, and they begin at Chapter 7 of the Bankruptcy Code. Chapter 7, Chapter 9, Chapter 11, Chapter 12, Chapter 13. Those are the 5 types of bankruptcy you can file in this country. A Chapter 7 is what we refer to as a liquidation bankruptcy. A Chapter 9 is a municipal bankruptcy. All right, let me ask, what's the average age of this room before I use this example?
30.
How old were most of you in 2010?
30.
5.
You were 5?
18, 14.
Back in 2010, the city of Detroit had to file bankruptcy. Chapter 9 is what they filed under, because Chapter 9 is a chapter of bankruptcy that only applies to municipal governments. Okay. Let me ask, can a state file bankruptcy if a state has debt? Could California file a bankruptcy under Chapter 9?
No.
Why not?
Because it's not a municipality. Because it's not a municipality.
There you go. Not only that, the state not being a municipality is something else. What is it?
A state?
It's a sovereign. It is the government. It's not an instrument of the government. When we say the sovereigns in this country are the United States and each individual state are what we call sovereign entities, meaning that they govern over themselves. They're not municipalities. Municipalities are arms of the sovereign, but they are separate and can file bankruptcy. For example, Puerto Rico right now, a lot of debt. Could Puerto Rico file a bankruptcy? Why not?
I believe because it isn't a municipality because it's not under a sovereign, right? I don't know how the statehood would work.
There is literally a part of Chapter 9 that says Puerto Rico can't file bankruptcy. I'm just letting you know that right now.
Oh, that's very
They did kind of a,
specific.
yeah, they did kind of a carve out for United States territories because, as you just said, they are not sovereigns. They are federal territories. So they are not sovereigns, and their own governments operate under the federal territory scheme. So when they did Chapter 9, they basically said, by the way, even though they're not sovereigns, territories can't file bankruptcy under this. So Chapter 9 is a municipal bankruptcy, and it's a restructuring bankruptcy because you can't do some things in the Chapter 9 that you do with other things. Like you can't sell Detroit. Okay, nobody can take Detroit and sell it. So what does it do? It's a restructuring. They have an administrator that comes in, looks at it. They say, we're going to cut this, but we're going to sell these assets. We're going to avoid these debts over here. We're going to restructure. Okay. Chapter 11. What's Chapter 11 for?
Multinational corporations.
Chapter 11 is a business bankruptcy. It is a business reorganization. The only people who can file a Chapter 11 are businesses. So, do we have any artists or small business owners in here? Okay. Let's say you're an artist, you have an LLC, you're the only person in that LLC. All right? What chapter of bankruptcy would you have to file for that LLC?
Would that be 11?
That is an 11, yeah.
Okay.
And those are kind of like a Chapter 9, but they allow a organization, a entity, to restructure their debts as well, avoid some debts, go through things, say, we're going to pay this, we're not going to pay that, we're going to pay this amount of this debt to this person. Chapter 11s are somewhat complicated. There is a plan proposed. It is proposed to the classes of creditors. A creditor is anybody a debtor owes money to. And the creditors then have to vote on it. There's a Chapter 12. Do any farmers? Any commercial fishermen? None of you qualify for a Chapter 12. Moving on. There is a Chapter 13 bankruptcy. That is most likely what your friend was suggesting to you, was a Chapter 13 bankruptcy, because a Chapter 13 bankruptcy is like a Chapter 9, Chapter 11, and Chapter 12, except it is for individual consumers. Right? And everybody in here is an individual consumer. That's how we look at it. So there are 5 chapters of bankruptcy, 3 of which do not apply to most people, the 9 which is only for municipal governments, the 11 which is only for businesses, and I would say it's only for businesses, but when could an individual person file a Chapter 11 bankruptcy, if ever?
When they're an individual business?
Like
No.
a sole proprietor?
No. Sole proprietors, well, I understand, but why wouldn't a sole proprietor be able to file a Chapter 11?
Because they're not functionally a business entity, they are themselves?
Yeah, so
A sole proprietorship is just you, yourself, individually doing business in another name.
yeah.
It is the default form of doing business if you don't file any formation paperwork. And a sole proprietorship is just you, individually, doing business in another name. Okay. So can an individual file a Chapter 11?
Have they?
Say what?
Have they?
Oh, yeah. Yeah. Why? They're rich.
Yeah, okay.
There is a Chapter 13 is an individual reorganization bankruptcy, and those are 2 that we're going to focus on, 7 and 13, because those are going to be the most applicable ones to everybody in here. Unless somebody is a billionaire somebody is secretly Detroit in fursuit.
I wish.
That's
I don't think you want to be
Where's the
Detroit.
line?
You don't want to be Detroit.
That's a
They do
kaiju.
deer.
Or one of you is running a farm. Okay. And why, by the way, why would you think that farms and commercial fishing operations, commercial family fishing operations, why do you think they have their own chapter of bankruptcy?
Probably because of just natural disasters, famine,
Nope.
They have
things
entirely
affecting
separate labor
their
laws?
stock.
Because historically they were a big deal, and when
Nope.
these laws were being
Because
developed.
food is important.
So what?
Because food is important.
Nope.
The various subsidiaries.
Does it-
Nope.
yeah, that's what
We just decided, so.
There you go.
Okay.
It's
That's how law works.
it's slightly more
It was
complicated than that,
decided
but
this way.
that's basically it. What happened is they didn't have Chapter 12 for a long period of time. So you had family farms and family-run commercial fishing operations that were filing for bankruptcy, and they couldn't really, like, they'd file under Chapter 13, but that wouldn't take care of their business debts. That would only take care of their personal debts. And they weren't making enough to really be debtors under Chapter 11. And for reasons you're going to see, they didn't want to file under Chapter 7. So there was really nowhere that family farms and commercial fishing operations were fitting in because they were hybrid business consumers. So they created Chapter 12, which takes aspects of Chapter 11 and aspects of Chapter 13 and combines them to make it easier for family farms and family-run commercial fishing operations to go through bankruptcy without losing the farm. Okay. I say without losing the farm. Right off the bat, I heard you have to give stuff up to go bankrupt. And I immediately said, no, you don't. All right. Is that always true? No, you don't. All right. So, the two chapters that we're talking about, Chapter 7, Chapter 13, here's what I will always call them. Chapter 7 is a liquidation. Chapter 13 is a payment plan. All right. In a Chapter 7 bankruptcy, and in a Chapter 13, well, first let me ask, what type of debts does bankruptcy deal with? What type of debts does it deal with?
Medical, imagine creditor.
Everything right over there. Not, by the way, not true, doesn't deal with everything. It may be better to ask what type of debts doesn't bankruptcy deal with.
Right.
Yes.
Aren't college loans excluded from
Yes,
bankruptcy?
they are.
Yeah.
You cannot discharge student, well, I shouldn't say you cannot discharge student loans in bankruptcy. You certainly can. There is a pathway to do it.
Good luck.
You don't qualify, trust me. It was at a point where in private practice people go, oh, my student loans, I go, we're not even going to go through that analysis. Why? Because you have both of your arms, both of your legs, and you can see. The test for the discharge of student loans in bankruptcy has been interpreted to be extremely high. It is a hardship-based test, and generally it is, if you can earn money, you can pay something a lot of times. So, before we get into Chapter 7, let me ask, and this is just kind of a poll. What have you all heard about bankruptcy? Like, what's your opinion of it? This is honest. What's your opinion of a bankruptcy? When you hear somebody's gone bankrupt, what do you think?
Oh no.
It's either a combination of someone has fallen on some really hard times and like shit's just gone bad for them, or it's someone trying to like offload debt onto someone else and make it go away forever. It usually seems to be one of the two.
Anybody else?
In the commercial sector, you start seeing the liquidation sales.
Anything else?
It wrecks your credit.
It wrecks your credit? Does it wreck your credit more or less than all the unpaid credit cards?
Depends on how long you've been not paying.
I used to have people walk in and into my office and they go, oh, but I don't want to ruin my credit. And I look at them and I go, when was the last time you paid your Amex? Well, I said, listen, I got news for you. Your credit's already wrecked. It's not getting any worse. This will actually help. That's people being irresponsible. Here's what I saw when I was doing bankruptcies. I didn't actually see a lot of people who were irresponsible offloading debt. That is kind of a stigma that gets attached. Most of what I saw, medical situations, people suddenly losing their jobs, every now and again, people who just got so far behind. They had one thing happen 4 years ago, and they've been playing catch up for 4 years, and they just can't get ahead on it. Those are the big ones that I saw. The other ones, somebody did not want to lose their house in a foreclosure sale, and they ended up coming in to file bankruptcies for that. Those were very common. Those were extremely common. Those are so common to the extent that there are lawyers in my office, did it as well when I was in private practice, that would once a month pull the list of all the foreclosure filings from the courthouse and send a letter to everybody on that list that said, if you're considering bankruptcy, give us a call.
Oh dear.
So, bankruptcy is designed, and we've had bankruptcy, first of all, as long as we've had the country. There's been some form of bankruptcy in the United States, and that all goes back actually to merry old England. In England, they had debtors' prisons. Who knows what a debtor's prison is?
Yeah.
What's a debtor's prison?
It's a prison they put people in debt in to pay off their debts.
Well, how do they pay off their debts if they're in prison?
They force them to work.
Yeah, they force them to work, or a relative had to come and bail you out. Somebody had to pay your debt, and that was the thing. They went to court, they would get a judgment against you, a judge would order you to jail, and you would stay in jail until somebody either paid your debt off or you worked off the value of your debt owed to your creditors. You know what one of the largest debtors' prisons in the world was?
Georgia?
Georgia!
Georgia.
Georgia was a colony that was completely founded as a way for England to empty out its debtors' prisons. The original settlers in the colony of Georgia all came from English debtors' prisons. And you know the first thing they did in Georgia? They abolished debtors' prisons. You know the second thing they did in Georgia?
They reinstated debtors' prisons.
No. They got rid of lawyers. No lie, when Georgia was a colony originally, they banned debtors' prisons and they banned lawyers from Georgia. Wow. Probably should have kept it that way, to be honest. So, when we broke away, one of the things we did not bring over the concept of debtors' prisons. So what does that mean? It means there's a lot of unpaid debt out there, and now people are having their property actually taken from their owning land. That land's being taken away from them. Banks are hesitant to lend money. Merchants are having trouble getting credit, and we developed the bankruptcy system for this country, originally for merchants, then moving out to other people and consumers on that, as a way to do what? Not just to get rid of debt, but to do what?
Protect lenders?
Protect the, yes, no. Protect the lenders. Yes, lenders, we're protecting you. By the way, they don't have to pay you anymore. No, we protected, or we protected the lenders, yes. No, that's now, that's not then. The bankruptcy system was intended and created to give a good, yet an honest but unfortunate debtor a fresh financial start. Okay, and those are key words, by the way. Honest but unfortunate debtor. Those actually come from a United States Supreme Court opinion regarding bankruptcy that defines the cornerstone of the bankruptcy system, the honest but unfortunate debtor. So how do they do that? Obviously you get an attorney, and that attorney sits down and says, all right, what chapter of bankruptcy are we going under? Right, if it's a consumer, we're looking at 7, we're looking at 13. Now, everything I'm about to tell you applies to both of those cases. Right. First, bankruptcy is intended to deal with your pre-petition debt. A pre-petition debt is a debt in existence prior to the filing of your bankruptcy. Right. So, if in 10 minutes, if right now, I suddenly have a debt appear, and right now, I file a bankruptcy petition, and right now, another debt appears.
Whoa.
Okay? I incur another debt. I go out right then, and I borrow $10 from somebody in the hallway. This debt right here, the debt I incurred prior to the filing of my petition, is handled in bankruptcy. It is a pre-petition debt. The one that I got borrowing $10 2 minutes after I filed the petition, that is not handled in bankruptcy. That's a post-petition debt, and I remain liable on that. Why does that matter? Pre- and post-petition debts. Why does that matter?
So you can't file bankruptcy ahead of time in order to get out of it?
Correct. But more than that, what's the goal of bankruptcy?
To try and get you a clean slate.
And in law, we call that clean slate the bankruptcy discharge. The bankruptcy discharge is the end goal of every single bankruptcy for a consumer. Because a consumer getting a bankruptcy discharge means all of those pre-petition debts are gone, with some exceptions. What are the exceptions?
College funds.
College funds, what else?
Taxes? Is that a debt?
Some taxes.
Okay.
Income taxes are not dischargeable. They continue through on both types of bankruptcy unless they are over 3 years old from the date on which they were assessed. So if I had a tax assessed in 2019, and assessed means the day the IRS says, we've determined you owe this much money. If I had a tax assessed in 2019, and I filed for bankruptcy in 2023, that tax is discharged if it's for income tax. It's an unsecured debt at that point. Okay? It was filed in 2020, that tax survives my bankruptcy, and I have to pay that. Now, how, and we'll go to this in a second when I talk about unsecured and secured debts. What else other than taxes? Child support. Domestic support obligations are not discharged in bankruptcy. Criminal restitution. If you're ordered to pay criminal restitution, that's not discharged in bankruptcy. I forgot the other one. Oh yeah, judgments from drunk driving accidents are not discharged in bankruptcy. And so, when you file, you're making that determination. Chapter 7 liquidation bankruptcy. What does that mean?
That's the one where you're selling your stuff?
Well, you're not even selling it. You don't get to sell it. The moment that you file a bankruptcy, you file something called the schedules. Right? And one set of the schedules is you're reporting the value of all of your assets. And that is all of your assets. Right? That is the value of your TV and your house. That is the value of your cat and the family jewelry. All right? You report it. You don't take into account what you owe on it when you report that value. Right? Because afterwards, say you have a house that's worth $200,000, but you owe $150,000 on it. Well, you report it for bankruptcy purposes as a $200,000 house. Right? All those assets, all of that goes into something that we call the bankruptcy estate that gets created at the time of filing. Right? Then you go in and you report that $200,000 house, I owe $150,000 on it. So now, for the purposes of bankruptcy, you don't have a $200,000 house, you have a $50,000 house. Why? Because the bankruptcy estate is all the property that will be of value during the bankruptcy. And if that house were to be sold, the creditor on it is going to get the first $150,000 because they have a secured claim. Right? Who knows the difference between a secured and unsecured claim?
A secured claim is when it's attached to some piece of valuable property, and unsecured means it's not attached.
Well, not even valuable property. It can be anything, but it's a debt that is backed by collateral. All right. Your house on a mortgage, your vehicle on a car note. K Jewelers, actually, believe it or not, in their credit agreements, has a statement that says, by the way, the jewelry you're purchasing is collateral for this debt. So K Jewelers can be a secured claim.
Yeah, I do that.
An unsecured claim is one that is not backed at all by any collateral. Right? So you deduct what's owed on all the secured claims from the value of that property, because secured creditors are always entitled to be paid up to the value in a bankruptcy. Right? So let's say right then we've got the $200,000 house, $150,000 comes off, we have $50,000 of value in the bankruptcy estate. If we stopped right there, the bankruptcy trustee, who is a person who's assigned to administer and oversee your bankruptcy, would say that house is worth $50,000 after everything else. I am going to sell it. I'm going to sell that house, I'm going to take that $50,000 and I'm going to give it to all the unsecured creditors pro rata, meaning if one guy owns 90% of your debt, they get 90% of that $50,000. And every other creditor fights over it. Now, we don't end there. Okay, first of all, the house isn't really worth $50,000 at that point, because we haven't taken into account the cost of the trustee selling it, right? So most jurisdictions let you deduct cost to sell. In the jurisdiction I practice in, for a Chapter 7, the cost of sale was assumed to be 10% of the house's assessed value, right? So now, we take that right off. 10% of $200,000, $20,000, it's a $180,000 house. Take off the credit, now it's a $30,000 house, right? Still has value for the trustee to sell though. So we go back in, and there's something called exemptions. What's an exemption in bankruptcy? An exemption in bankruptcy is a way for you to say, yes, I know I'm going bankrupt, however, I get the value or a portion of the value of this type of asset. Right? And there's two types of exemptions. There's the state law exemptions and there's the federal law exemptions. These state law exemptions are going to be whatever your state has said. These are our bankruptcy exemptions. The federal law exemptions are very much set in stone, but you don't get to choose between the two. Now, you can't go back and forth. Number one, if your state allows you to, you got to choose one or the other. You got to stick with them for everything. Number two, you may not get the choice because your state can actually say, and several of them, most of them do, you can only use our state exemptions if you live here and you're filing bankruptcy in our courts. The code allows for that, by the way. Other states say you can only use the federal exemptions. Some states say it's your choice between the state and the federal exemptions. Now, when I practice in private practice, I almost never suggest to people use Pennsylvania state law exemptions because they're horrible. Instead, I go to the federal law exemptions, and that's what we're going to use here. So we have a $30,000 house. You live in the house. Right? The bankruptcy exemption for your home, your primary residence, is, last time I checked, about $25,000. So I take $25,000 of value out of that, saying, trustee, if you sell that house, after you pay that creditor, before these unsecured creditors get a penny, my client gets $25,000 of the money it gained. So now, what's in the bankruptcy estate? I mean, we're at 30 grand, we're at 5 grand now. Right? Will the trustee sell your house over $5,000?
Probably not.
Probably.
Probably.
Probably. Every trustee is a little different. Because let's take it a little different. Let's say we get that down to zero. Let's say the value of your house, or let's say you owe $155,000 rather than $150,000. Now the value of your house in the bankruptcy estate is $0. What happens? Do you lose your house? No. Why?
It's not worth selling.
It's not worth it to who?
The various creditors who are...
And the various creditors are represented by one person. That one person is the trustee. And the trustee's going to bankruptcy. A, make sure you're not committing fraud. B, make sure your plan's proposed in good faith. Make sure the bankruptcy's brought in good faith. C, to get maximum value for the unsecured creditors, the ones who don't have a security interest. If your house is worth $0 after we do all the bankruptcy deductions, it's of no value to the bankruptcy estate. Selling it won't realize any gain for the unsecured creditors. Why have the trustee waste time and money administering it? So they abandon that property, you keep your house. You still got to pay your mortgage, but you keep your house. And that happens with a lot of property. Most Chapter 7s that I would file, we would call no asset Chapter 7s. And it doesn't mean that my client lived under a bridge. A no asset Chapter 7 simply means...
Not including assets in the...
Pardon?
You're not going to include assets in the...
No, you have to report every asset, so they are included.
Oh, but they're not being actioned upon.
Right. After exemptions and deductions, every asset that is listed is of no value to the bankruptcy estate. The trustee has nothing to administer. The trustee abandons all property back to the estate, gets out of the case, and the court grants a discharge. and you don't lose anything. You keep everything. Everything you have. Now let's say that there is stuff that will be sold. Let's go back to your house is now worth $5,000 to $10,000 to the bankruptcy estate. Okay? What happens? Do you want to lose your house?
No.
So in that situation, what may I do?
Buy your house back from the estate?
If you have the money to buy your house back from the estate, you have $5,000 in assets, and that money is actually part of your bankruptcy estate already.
Okay.
You file a Chapter 13. Here is in a Chapter 7, they sell your stuff to pay your unsecured creditors. In a Chapter 13, nothing gets sold. Not unless you want it to. In a Chapter 13, everything that I just described happens. The reporting of asset values, the deduction of credit, secured claim amounts, the deduction of exemptions from the bankruptcy estate. All that happens. But in a Chapter 13, you propose a plan of reorganization. And the rule of thumb for a Chapter 13 is an unsecured creditor cannot receive less in a Chapter 13 than they would receive if you went through a Chapter 7. Okay? And that's because people will go into a Chapter 13 with more than sufficient funds to pay. But they want to reorganize the debt. Sometimes they will propose not paying the claims as much as they would in a Chapter 7. And in that situation, you would have to build a plan that at least provided for the equity of your house, the $5,000 plus trustee fees, plus attorney's costs, things like that. In Chapter 13, what is the trustee's job? Once again, watch for fraud, make sure the petition is filed in good faith, and they administer your bankruptcy plan. They are the person who looks over your bankruptcy plan. They are the person who suggests to the court that they approve the bankruptcy plan. You make your plan payments to the trustee, and the trustee distributes it according to that. Now, there's another reason outside of saving assets when you have equity. And in that, you'd pay the $5,000 at least on that. Because really what you're paying is you're paying 100% of your disposable monthly income based on a calculation that's made by your attorney into the plan for a period of time. That period of time is either going to be 3 years or 5 years. It depends on where you are income-wise. If you're what we call a below-median debtor, you're required to commit for 3 years. If you're above median, you're required to commit for 5 years. Below median can commit for 5 years to the plan, but can't go longer than that. When I say median, what am I talking about?
Median household income?
Median household income for your household size in your state as of the date of filing, yes. And the United States Trustee's Office actually does keep a list that's updated every 6 months on that. Now, if you're above median, can you file a Chapter 7?
Sure.
No?
Why not?
Because of how Chapter 7 bankruptcies work. They put into place, back in 2006, the Bankruptcy Abuse Prevention and Consumer Protection Act. I would tell people, ignore the name, it does none of that. What it does is it made it harder for people to file for and receive Chapter 7 discharges. And one of the ways it did it was saying, we're going to means test Chapter 7 bankruptcies because they have a tendency of getting discharges with no payments. Right? Prior to that, we used to use what was called the substantial abuse test. And it was on every single case, you would tell the court, this is why allowing my client to go through a Chapter 7 is not a substantial abuse of process. Right? Insurance a lot of the time, or sometimes. Pet food every now and again, things like that. And if that comes out to above, for a 60-month period, it comes out to a monthly amount, they multiply that by 60, that gives what they call the base amount. The assumption being that if you went into a Chapter 13, you would have to pay at least that much per month. So you multiply it by 60, that gives the base amount. If the base amount is less than, last time I looked it was $7,800 over 60 months that you have available to unsecured creditors, they go, okay, it's not abuse to let you go because the unsecured creditor, the plan's not going to pay enough to unsecured creditors to make it worth it. If it was between, I think it was 7,800 and about 13 grand, they said, okay, does it provide to pay 25% of the unsecured debt? If it does, then they need to be in a Chapter 13. If it doesn't, it's not worthwhile to put them in Chapter 13. They go to Chapter 7. If it was above $13,000, you had to be in a Chapter 13. You could not seek a Chapter 7 bankruptcy. Right? So, when we do that, when you're going into a Chapter 13, you come up with the plan, you propose the plan, you make the payments on the plan over that time period to the trustee once the plan is confirmed. Upon successful completion of that, you get a discharge. Now, I said when the plan is confirmed. What's that mean?
Creditors vote on it.
If we were in a Chapter 11, you'd be right. Because that is how a Chapter 11 works. In Chapter 13, the creditors don't get a vote. What does it mean by plan confirmed? Who's confirming your plan?
Trustee?
The trustee suggests it for confirmation. The trustee doesn't confirm it.
A judge.
There you go. The bankruptcy judge. And why is that important? Because it becomes an order of the court. And why is that important? Because that removes any discretion the creditors have. They don't have discretion. The creditors don't get to say, we don't like this, so we're not going to recognize it. If your Visa card gets a grand total of $2 on a $100,000 credit card bill and the court confirms that plan, Visa gets $2 and they never get to come after you for the rest. Okay? And that happens a lot. Now, I talked about equity. If you have equity in your house, you definitely are going to want to go into a Chapter 13 because that's where they won't sell your assets. All right? If you have non-exempt equity, you definitely want to look at that. I also talked about your plan has to provide 100% of your disposable monthly income. What's another situation where you may want to do a Chapter 13 instead of Chapter 7?
I think maybe if you yourself own a LLC and the LLC is its own entity, you don't want to lose the LLC, but you can.
Yep, no, that's valid. Although, would a Chapter 7 necessarily take away your LLC if you're filing bankruptcy?
No.
I'm not sure.
No, it wouldn't. Your LLC is simply your property. So the same as any other asset, you could exempt it out.
Okay.
Okay. What about if you fall behind on your mortgage? You fall behind on your mortgage and they filed a foreclosure action. Can Chapter 13 help with that?
We're so unprepared, we're sorry. That's okay.
Yeah, certainly. A Chapter 13 plan can propose to pay off mortgage arrears. I would call them keep current plans. What you do is in the plan, you put now everything that you owe as of the date of filing, everything you're behind on, not the entire mortgage amount, but what you're behind on. If you missed 5 months, 5 months worth of payments into your plan to your mortgage lender. And then as you're making those payments to the trustee every month, you also make your regular monthly payment to your mortgage lender outside of the plan. And as long as the plan goes all the way through to completion, your mortgage lender's arrearages will be cured and you will have kept current outside of the plan. It's a wonderful way to do it. I saw a lot of people do that. If a debt becomes due during the course of the plan, you do have to provide to pay in full in most jurisdictions. What's another reason you may want to go with the Chapter 13? Credit card debt. Say you think you can pay off the credit card. You may actually make enough money to pay all of your secured creditors in full over the course of 5 years. We call that a 100% plan. And what that means is every single creditor is going to be paid in full through this plan. So why would you do that if you can pay them in full? Why would you file bankruptcy if you have enough money that over the course of 5 years you can pay every single creditor in full?
Because they don't get to charge interest.
Stops interest? They do get interest, by the way. They don't get as much.
Because it guarantees it happens over 5 years instead of if it was like a 1 year loan.
There we go. You can look at it and say, I can pay you all, but I can pay you over 5 years. If you called Visa right now and said, I can pay you over 5 years, but I'm going to send you an amount that I want over those 5 years, and by the way, stop charging me interest. Are they going to say, yeah, that sounds good? No, of course not. It lets you reorganize your debt. Hence why it's a Chapter 13 reorganization. What's another reason you may want to go with a Chapter 13? Let me give you an example here. You had fallen on hard times. You lost your job. Somebody got sick. Something happened. You have not been able to pay your mortgage for 3 or 4 months. The bank has filed a foreclosure action. You have lost. They have been given a judgment of foreclosure, and your home is scheduled for sheriff's sale on Friday. What can you do on Thursday?
The bankruptcy filing.
What effect will that have? What effect will bankruptcy filing on Thursday have on the sheriff's sale on Friday?
Stop it.
Holds all that stuff in suspension while everything is being dealt with.
Right. A bankruptcy filing of any type imposes what we call an automatic stay of proceedings. That you actually find that in 11 U.S.C. 362. An automatic stay is basically the court telling all the creditors, while this bankruptcy is ongoing, we're hitting the pause button on every bit of your collection activity. You cannot, without court permission, take any further action to collect on any debt owed by the debtor. Pre-petition debt owed by the debtor. And if you do, with knowledge that the bankruptcy has been filed, we're going to sanction you. And it's going to be a heavy sanction. So if you file a bankruptcy on Thursday with a foreclosure sale on Friday, a good lawyer will file it, get the notice of bankruptcy, and fax it to the sheriff or whoever does the foreclosure sales with the statement of, don't do it, we filed a bankruptcy. Does that mean that the lender can never proceed while the bankruptcy is active? No, of course not. Let's say you file a bankruptcy and you then don't make any mortgage payments. You have a Chapter 13, but you don't make any of the mortgage payments to catch up. Right? You made no post-petition plan payments to your mortgage lender. Now, the lender has been forbidden by the court in your filing in the automatic stay, which goes into effect automatically from proceeding. Now they want to proceed. Can they?
Yes.
With court permission, yes. They file what's called a motion for relief from the automatic stay, saying, court, we have a reason to get out of this now. They haven't paid us anything since the filing. We're losing value on this property. We have cause. We would like you to give us relief from the automatic stay and allow us to proceed with the foreclosure. And the court, 9 times out of 10, give it to them. By the way, would you ever want to just file a bankruptcy to stop, a Chapter 7 bankruptcy to stop a foreclosure sale?
Probably not.
No, why?
They're gonna liquidate it all.
There you go. Whether there's a value to the estate or not, immediately the lender's going to come in and say, court, number one, it's a liquidation. Number two, they're behind in what they owe us. So we already have cause immediately. Number three, this is the Chapter 13. And the court's going to say, no, they're right. When I have people come in and they go, oh, I'm 2 months behind on my mortgage, I go, can you get that caught up before we file? Why? Because it's going to be the difference between a Chapter 7 and a Chapter 13. If you are in arrears on the date of filing, I'm not going to put you in a Chapter 7. You'll lose your house. They will get relief from the automatic stay. You will lose your house. And we put them into a Chapter 13. Now, that was a real normal sort of thing to happen there. So it goes through, you have your Chapter 13 in place, you're paying off your debts. What now? You get to the end of your whole plan. What now? Yes? You're good. It's actually the best way to put it, yes. You will receive your bankruptcy discharge. And it's not that hard to get there. It really isn't. When I was doing this, the most common reasons that people did not get bankruptcy discharges were A, they lied to the trustee. B, they lied to me. C, they did not make their plan payments. If you don't make your plan payments, the trustee will ask the court to dismiss your case, and the court will do it. Or D, something happened and they were able to complete the plan early or dismiss the case. They didn't need the discharge anymore. A good example, somebody goes into a Chapter 13 bankruptcy, they're planning to pay off their arrears to the plan, keep current on their mortgage. 2 years in, they say, I want to sell my house. You know, I've got equity, I'm going to sell my house, I'm going to move out, I'm going to get a smaller place. And I'm going to use the proceeds to pay off the balance of my bankruptcy plan to get an early discharge or dismiss. Okay, would that work?
Probably.
No. No. You know why?
Oh, because the house is part of it.
2 years. But I say, if you're a low medium debtor in a Chapter 13, you're required to commit to the plan for 3 years at a minimum. That means that during that 3-year period, the trustee has a claim on 100% of the assets that you bring in for your unsecured creditors. So if your plan in the Chapter 13 does not already provide for a 100% payment, you can't just pay off the plan balance after 2 years by selling your house and walk away with the rest. The trustee's going to come back and say, okay, you can sell your house, yes. Now, every penny that we get from that sale after paying off the secured creditor comes to us. And then we're going to pay off your unsecured creditors, and if there's any left, we'll give it back to you. But we're going to do that. You don't just get to pay off the balance. At 3 years, however, at 3 years, you can pay off the plan balance, and I've done those before. I had proposed plans for a 5-year period with a low median debtor who's required to commit to 3 years. And maybe it paid $6,000 of $150,000 in unsecured debt. All right? Maybe that's all the unsecured creditors got out of it. And the client would say, I'm going to sell my house, and we want to pay off our plan balance because we looked at it, and our plan balance left is only $40,000. Right? I go, hey, you need to wait. If you sell it right now, the trustee's going to take every penny and give it to the unsecured creditors. 2 months later, they're at their 3 years. They come back and they say, okay, now can we sell it? Yeah, we'll put in a motion to the court, for the court to approve the sale. What's the difference? You've hit the 3 years. Now if the trustee says, oh, we get all of it, you go, no, they're below median debtor. They were only committed for 3 years. The 3 years are over. They're going to pay off that $36,000, and then they get to walk off into the sunset the $100,000 in equity they got from the sale of property. It's a wonderful thing sometimes. And what is this getting at? It's a way to say, over the years and over the decades, bankruptcy has been villainized. There's a heavy stigma to it. And I'm very aware of that. When you hear somebody is bankrupt, the first thought is maybe it's a medical issue. Then the second thought is, or they're just trying to get out of paying their debts. And like I said at the very beginning, I did bankruptcy for a long amount of time. I almost never saw anyone in my office who was just trying to get out of paying their debts. There was always people who couldn't pay their debt. And there's a difference there. The honest but unfortunate debtor. And it is the financial fresh start. But when they say, oh, they're bankrupt, therefore they're irresponsible, the question becomes, if that is the situation, why have we had it since the formation of the country? Why was it so important that the founders of this country said we need to have a form of bankruptcy? Because they recognized the need for a financial fresh start. What are other options for instead of bankruptcy? If you're in a lot of debt, what's another option?
You run.
You run? No, that's called fleeing the country. Fake your death is not really a valid option.
But it is.
But those
Debt consolidation.
debt consolidation. When you say debt consolidation, what do you mean?
Like, I know there are some companies that help like negotiate
That is not debt consolidation.
Oh, okay.
That is debt negotiation, debt settlement. Debt consolidation is simply you take out another line of credit of some sort, either a personal loan or something like that, and you put all your debt, all your unsecured debt on that one. Why would somebody do that?
Student loans.
Yeah, that's the same thing as rather than having 8 loans and interest rate, you have them on one loan.
Better interest rate.
But why would somebody do that with, say, their credit card debts?
Lower interest rate.
Lower interest rate. It can take, instead of making 6 payments each month at 23% interest, you can make 1 payment at 6% interest to the person who gave you, or the bank that gave you the personal line of credit. That's a valid option. Debt negotiation, like you talked, debt settlement. Who here would think that that's a valid option? Those companies that say, come with us, we'll negotiate your debt.
It's like I've done it.
I always say they're a valid option. They're no better than bankruptcy. They tend to cost you a lot more money because a lot of times the way the debt settlement company works is they wait for the original lender to sell the debt to a secondary collector that they can negotiate with. And that monthly payment you're making to them is going into escrow for them to pay off the settlements and going to them directly. But since they don't tend to make payments in that time frame, you're already taking a credit hit. You're already taking the credit hit by going into that settlement because you're going to be late on things. And I guarantee you that in the vast majority of situations, what you are paying monthly to the debt settlement company is more than you would pay monthly to the trustee for it. Every now and again, I will run into people who can't file a bankruptcy. Even though a Chapter 13 in theory is open to everybody, I will run into people who cannot file a bankruptcy. Why?
Not a U.S. citizen?
And that's one. Anybody?
They make too much money?
There's no such thing as making too much money. No, there is.
I meant like for the...
No, there is and there isn't. It's not that they can't file a bankruptcy. It's that it doesn't make sense to file a bankruptcy. If I made $1 million a year, I can file a Chapter 13 bankruptcy. My bankruptcy will provide for 100% of my creditors to be paid 100% of their value over the course of 5 years. But why would the court stop me from paying my debt in full over five years? A Chapter 13 does not really feature an income bar. It's not like a Chapter 7. Now, you can owe too much money to file a Chapter 13. I believe the unsecured debt limit in a Chapter 13 is, the last time I looked, it was $300-something thousand. But if you owed over that in unsecured debt, you could not file a Chapter 13 whatsoever. They wouldn't let you. They'd say you owed too much, you had to go under a Chapter 11 debt. The other way that people can't file bankruptcy, they've already filed bankruptcy. When I say that, I don't mean they've already filed bankruptcy ever. I mean, they've already filed a bankruptcy in the last year. And even then, they can be a debtor. They can go into bankruptcy. It just affects how the automatic stay will work. However, and this is a weird one, if you go into a Chapter 13 bankruptcy, your creditor files a motion for relief from the automatic stay, and then you move to dismiss your Chapter 13 bankruptcy to keep them from getting relief, your case will be dismissed, but you can't file another bankruptcy for 6 months. But if you file bankruptcy too many times, you'll be a serial filer, the court will bar you from it. This is a good one, if you commit fraud in a prior bankruptcy case, the court will bar you from refiling. The court will say, bankruptcy is a privilege and you've abused it. You can't file bankruptcy again. It's very rare to see those. But almost anybody can file a bankruptcy and go right through with it. It's not a huge issue to have that happen. The key that I'm trying to get at, and I've been trying to get at, is many times we treat it like it's this horrible thing that there's no way out of. There's always that option available to you. And with that, we have 5 minutes. I'll take a couple questions if anybody has any. Yes.
What's the general time span or speed of things?
It varies. When I was practicing, I would tell people in my court that beginning to end on a Chapter 7 is going to be about 6 months from filing to discharge. On how long it takes to file, I tell my clients, that's up to you. If you get me everything I need tomorrow, I can file you next week. Yes.
If you're like running a business and you have a lot of debts, is there any benefit to like having an LLC that have those business debts rather than it being like in your name?
There's always a benefit to having an LLC for those business debts, but what you have to watch is you have to watch intermingling. Make sure they can't come through the LLC to you, and you also have to be aware that many times when an LLC is just starting, they don't really have a history, a bank is going to want you as the owner to personally sign for that as well. Again, do one more and then we'll call it. Yes?
When they're figuring out the value of the estate, do they just go on like sticker price, or like I could sell this?
This is fun.
Something for like.
Yeah, this is fun. It is. You are entitled. Every district's a little different in the way they do it. But generally, the rule of thumb is you're entitled to report it at the value that the trustee could reasonably expect to receive for it. Okay? So, with the house in my district, you know what we did? We went to Zillow and Redfin. Because our trustees had said, we'll accept Zillow and Redfin as estimates of value, and we'd find the cheapest one. And if we thought Zillow and Redfin were too high, we'd get an appraiser in to give us a sale appraisal on it. But it came to like personal items, your pots, your pans, your kitchen table. I'd give my clients a list, and I'd say, just go down this list, fill in what's not on the list, and give me a yard sale value. What a yard sale value, and not what you demand for it at a yard sale. What you would actually pay for it at a yard sale. Why? Because you know how the trustee sells your personal effects?
Yard sale.
They have an auction. They have a personal property. You ever seen a state auction?
Yeah.
And everybody always thinks a state auction, ooh, someone died. Yes, that's one type of estate auction. Another type of estate auction is the bankruptcy estate. And that's how the trustees will sell things in that. So, yeah, you got to be realistic. You don't want to say, I have a Rembrandt and it's only worth $40, but, because they will. Like, if they find out you lie on these things or you're intentionally concealing stuff, you're done. Because that is bankruptcy fraud. And you know who the trustee is representative of? You know who the trustee works for?
The government.
Say what?
The state.
The state? No. The Department of Justice.
Yeah.
There are two sides to the Department of Justice. There is the criminal side that we all know about, the U.S. Attorney's Office that does criminal prosecutions. And then there's the civil side. The largest portion of the Department of Justice's civil side is the United States Trustee's Office. And every trustee wanted to be a United States attorney, and they will refer you for prosecution. They will. I would tell clients, I'm like, don't lie to the trustee. They've got a chip on their shoulder. They will refer you to prosecution. And I do not handle bankruptcy fraud prosecutions. So, with that said, I've got to go ahead and hand the room over to our next panel. Folks, thank you so much for joining me. I'm sorry I was a little disjointed. I stayed up far too late last night drinking. So, I hope you have an enjoyable rest of your cons. And if you have any questions, please do not hesitate to track me down and ask me, okay? Thank you.
Thank you.
Silver Gato Man, he bought me a coffee. Silver Gato Man, here is the song for thee. He likes to video all the panels at the cons. You should go and watch them whether they are short or long. Silver Gato Man, you video that's not a jibe. All of you go to his YouTube channel and like and subscribe.